As you can see from the title of this video, we will be explaining your legal right on redundancy, how the process works and what to expect. Welcome back to The Law Process.
With me, Jade.
And me, Grace. If you haven't subscribed to our channel already, you're already here. So make sure you subscribe, make sure you like and comment on all our videos.
If you're new to our channel, I'm a data privacy associate.
And I am a trainee solicitor.
And we are here to educate, motivate and update you as we take you on a journey to success.
That's right.
Unfortunately, as we may all know, more and more people are being made redundant.
Yeah.
This is due to the impact of coronavirus and the recent news that we are officially in a recession.
Yes, we have already seen figures from the Office for National Statistics that about 600,000 people have been made redundant between March and May. So therefore we thought it would be a good idea to give you guys this video for anyone who's going through a redundancy.
Yeah, or may go through one in the future. So what is redundancy?
Redundancy is a situation where your employer have to let you go. It is a form of dismissal when a company needs to reduce their workforce.
Legally speaking, under Section 139 of the Employment Rights Act, you can be made redundant if your employer falls into one of these three categories. Number one, the business has closed down. So for example, if you were to work for company X, this would mean that company X no longer exists. Number two, workplace closure. So this means that the particular location that you work in has closed down and other sites may have closed down too.
Yeah.
So it may not mean that the whole company has closed down, but where you work is closing down.
Yeah.
Number three, there is no or less work for you to do. So if within your role there was 2 or 3 people that had similar job responsibilities, but this could now be done by just one person, those other people that are no longer required could be made redundant.
So let's move on to what your employer have to do before they can make you redundant.
Before your employer can make you redundant, they must follow the following 3 steps. Number one, they must consult you or your representative about the proposed redundancy.
If less than 20 people are being made redundant in your company within less than 90 days, then the company must conduct an individual consultation. If the company are making 20 or more people redundant, again within less than 90 days, then they must conduct both individual and collective consultation. So with the collective consultation, they must gather everyone who is being made redundant together and warn them. This must be done within 30 days before the dismissal takes effect. However, if 100 or more employees are being made redundant, then that consultation will need to be done at least 45 days before the dismissal.
The consultation should include discussions on ways to avoid the dismissal, how the number of dismissals can possibly be reduced, and ways to mitigate the financial loss or risk involved in the redundancy.
And you may also raise any issues or concerns that you have at the consultation.
Yes. And at this stage, an employer may ask some people to volunteer for redundancy.
Yeah.
But it's at the employer's discretion who they choose to make redundant.
Number two, the redundancy must be fair. So they have to adopt a fair basis to select the people for the redundancy. Your employers need to decide how they're going to pick the people that will be made redundant from a selection pool. And ideally, they should be discussed with you at the consultation meeting. The reason for selecting you cannot be based on a personal characteristic. So for example, your age or your gender, as this could potentially be a discrimination claim. The criteria used to select people should be measurable. So for example, it can be based on length of service, your performance and your attendance records.
Number three, your employer must consider alternative employment for you. If the alternative employment that they're offering you differs from your current contract of employment, then you can be put on a 4-week trial period. This trial period will allow you and your employer to see if you're suitable for the role. If at the end of it you decide that, no, this isn't for you, and your employer agrees, then you can still be made redundant. If you get to the end of your trial period and your employer is happy for you to stay in that alternative role, but you're not so keen on it and don't have a justifiable reason as to why you shouldn't stay in the role, you can leave the company and not take up the role. However, you would lose the right to a redundancy pay if you were entitled to any in the first place.
Yes, so if the company makes you redundant and have failed to follow the 3 procedures we've just mentioned, then you as an employee can potentially bring a claim for unfair dismissal.
It's important to note that with the consultation periods we've just been talking about, your notice period does not kick in yet. Your notice period only kicks in on the date that you're made redundant.
You should be given the correct amount of notice. So if you've been working for the company between 1 month to 2 years, then you're only entitled to 1 week's notice. If you've been working for the company for over 12 years, then you're only entitled to 2 weeks notice. However, in between the 2 years and the 12 years, you're entitled to additional 1 week's notice for each year.
Yes, and if you are made redundant, then during your notice period, you should be given reasonable time off to attend interviews, and you should still be paid your normal salary for this.
If you are made redundant, then you may be entitled to a redundancy payment.
Yes, but the amount that you're entitled to depends on your age, your weekly salary, and how long you've worked at the company for.
However, your length of service, which is how long you've been at the company for, is capped at 20 years. And also, if you are made redundant on or after the 6th of April 2020, then your weekly pay will be capped at £538.
Based on your age, if you're under 22, you'll get half a week's pay for every full year you've been there.
Yeah.
If you're between 22 and 41, you'll get a full week's pay for every full year that you've been there.
Yeah.
And if you're 41 and over, you'll get 1.5 weeks pay for every full year that you've been there.
However, it is very important for you to note that you're only entitled to a redundancy payment if you're an employee and you've been working for the company for 2 years or longer. Also, if you've been on furlough before you got made redundant, it is also important to remember that your redundancy payment should be based on your actual full salary, not your furloughed salary rate. You can calculate how much you're entitled to on the Gov website, and we're going to put the links in the description box below.
If you're entitled to a redundancy pay, but your employer is refusing to pay you, then write them a letter. For whatever reason they're still refusing to pay you, then contact ACAS. Once you've contacted ACAS, you can then take your employer to a tribunal. You have up to 6 months after being made redundant to bring a claim against your employer through the tribunal. However, if your employer is insolvent, then you can bring a claim to the Department for Business, Innovation and Skill for a payment through the National Insurance Fund. We'll put a link in the description box below which will explain how to do this. If you're not entitled to redundancy pay, but you feel like you've been put in a compromising position and the procedure has not been completely fair, then you can ask for a settlement agreement. This is an agreement whereby your current employer will pay you a sum of money which will prevent you from bringing a claim against them later on. However, it is at their discretion and they do not have to pay you out or sign a settlement agreement if you are not entitled to a redundancy pay. Before we close off this video, here are some quick points to remember. The first one is being at risk does not automatically mean that you'll be made redundant. Once you're put at risk and you're going through the consultation period, this is your chance to fight for your position. Express to your employer what you do and what you bring to the role. Explain for any alternatives that can be made to reduce redundancies.
Yes, and also make sure you get everything in writing. Your employer should provide you with written details on who's been made redundant, why you were chosen to be made redundant, the redundancy process, and your redundancy payment.
Finally, if you get made redundant, make sure your employer supports you. Ask them for references on your LinkedIn and references for your CV and a potential opportunity that you could go to.
And also, if your company offers an outplacement services, make sure you use this to your advantage.
And for those of you in this position and looking for jobs, the government has launched a job help site to help you search and apply for jobs. We'll put a link in the description box below which will take you to this site. We'll also put a link to a comprehensive list of companies in the UK that are currently recruiting. And finally, if you do have any questions on the redundancy process, make sure you comment down below.
Yes, and you can get more information about redundancy from the Citizens Advice Bureau and the ACAS website. And we'll put the link in the description box below.
That brings us to the end of our video. Make sure you comment, like and subscribe and stick around for more.
Yes, and we shall see you in our next one. Bye!